I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? How's everybody doing? Happy Friday. This is Colin. All right. I've got a wild one for you today. It's a wild one. And then I've got a couple palate cleansers after this. But this one, if you guys remember the Judge Middleton hearing from about 2 years ago, that kind of started off the court tube community. Was the one where a man who was in a hearing for a PPO violation called in from the victim's house, and Debbie Davis actually called the police while he was there, and he got arrested on camera. And that, I think that was one of Law Talk with Mike's first videos, but that was a wild one. This one is kind of close to that. I don't want to give too much away. He's in jail now, so he's no longer at our house. But you'll hear what happened. And yeah, it's wild. For all you fast forwarders out there, fast forward to where the prosecutor's talking, because that's when he tells the judge what happened. That's where it's good. So before we get into it, you already know what to do. Like and subscribe. And do your jump kick backflips if you haven't already. Let's go.
All right, over at the jail, what's your name, please?
Jordan Garhart, Your Honor.
All right, Mr. Garhart, today you're here in court for a few things, but we're going to start with a new charge filed by the city of Lacey alleging violation of a protection order yesterday, October 18th of this year. Have you had a chance to talk to Ms. Camiri before court today?
Yes, Your Honor.
Ms. Camiri?
Yes, Your Honor. We are requesting that Mr. Garhart be released on his personal recognizance. The facts underlying this is that Mr. Garhart was found outside the residence of the protected party. It was Mr. Garhart's understanding that he was not to be near the protected party, but not that there was a limitation on distance to where he could be. His father recently died, and he had been living at that residence, and he needed to get a copy of the death certificate so that he could process the estate. He was unaware of the 1,000 feet limitation, and therefore did not believe that he was in violation of the protection order when he went to get mail from an unoccupied residence. This information regarding his understanding of the protection order was provided to the police. And so we're requesting that he be released on his personal recognizance today.
So a plea of not guilty then?
Yes, Your Honor.
All right. And let's see.
And we are not
And,
stipulating the probable cause, Your Honor.
Say again.
We are not stipulating to probable cause, Your Honor.
Okay. And it looks like Ms. Hickok has been appointed on the other case that is coming up for pretrial, so I'll appoint her on this case too, or specific point. Okay. All right. Mr.
Here
Sharp,
comes the waterworks.
do you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor. I do, Your Honor. Sorry.
It's the probable cause.
Yeah, there were multiple police reports containing this information. For counsel's benefit here, I'm reciting this from the report 2023-5215, just so there's no confusion there. This information comes to the report of Officer Gerkman, the Lacey Police Department. He writes that on October 18th at approximately 14:23 hours, he was dispatched to a no contact order violation reported to be occurring in the Lacey Park Apartments on College Street in the city of Lacey. The reporting party, Ms. Del Rosario, claimed her fiance was at the apartment complex per his phone location. She relayed to dispatch that there was a no contact order between him and that Mr. Gerhardt was not allowed to be there. She stated that he was not at the apartment. She was just seeing that his phone location is pinging there. Dispatch found a record of the no contact order attached to the service call, and dispatch informed the officer that Mr. Gerhardt was reportedly in possession of firearms from his previous arrest. Officer arrived in the area 1 minute later, requested the most recent DOL photo for Mr. Gerhardt, as well as vehicle registration information. The photo was attached. Officers made aware of a red Subaru Impreza with the plate number provided. Officer began searching the area. Corporal Stanford, Lacey Police Department, also arrived in the area. Corporal Stanford contacted Ms. Del Rosario while the two officers were parked right next to each other. Corporal Stanford that Mr. Gerhardt drove a white Kia Soul. While they continued to speak, Officer Gerkman continued looking around, looking for a Kia. On the south side of building C, noting that Ms. Del Rosario resided in apartment C301, Officer Gerkman located a white Kia Soul, appeared to have a male driver behind the seat matching the description of Mr. Gerhardt. Next to the Kia was a red Subaru Impreza with the license plate matching that previously provided by dispatch. Officer approached the male, recognized him as Mr. Gerhardt from the DOL photo, and when asked, he did identify himself as Mr. Gerhardt. Officer directed him to step out of the vehicle, which he did. He was detained in wrist restraints, frisked for weapons, seated on the patrol vehicle's bumper. Officer informed Mr. Gerhardt he was being detained as he was investigating an alleged order violation and that he was unable to be within 1,000 feet of Ms. Del Rosario's residence. Mr. Gerhardt said that he had shown up to get things out of his car and to get his mail. He said the judge told him he could collect his mail and Ms. Del Rosario wasn't there at the time. Corporal Stanford pulled up the no contact order, verified that it was served and valid. The order specifically states Mr. Gerhardt could not come within 1,000 feet of Ms. Del Rosario's residence, where the Officer Gerkman had witnessed and located Mr. Gerhardt and recorded on his body camera was well within 1,000 feet. There's a bit more information. I believe that's sufficient, but I'd like to continue if I could. This is relevant to the later parts of the hearing here.
This is where it gets good. Well, not good, really bad, but juicy. Let's say that. And I just accidentally rewound it like I always do.
Officer Gerkman, Lacey Police Department, he writes that was attached. Officers made aware of a red Subaru Impreza with the plate. He was detained in wrist restraints, frisked for weapons, seated on the patrol vehicle's bumper. Officer informed Mr. Gerhardt he was being detained as he was investigating an alleged order violation. He said that Ms. Del Rosario, he was Ms. Del Rosario's co-worker, and that she had informed him that Mr. Gerhardt had come over on October 17th and violated the order. Mr. Gerhardt was, earlier in the day at about 10:30. All
right, here we go. Sorry about that, guys.
Contacted by a third party, Mr. Barr. He had reported, he had called to report that Mr. Gerhardt was harassing him. He said that Ms. Del Rosario, he was Ms. Del Rosario's co-worker, and that she had informed him that Mr. Gerhardt had come over on October 7th. The order. Mr. Gerhardt was, Mr. Barr told the officer he was trying to get Ms. Del Rosario to report the crime, but he hadn't directly witnessed it as he had not been there. With the information in mind, Officer Gerkman contacted Ms. Del Rosario, asked her about the incident from that morning. She informed the officer that Mr. Gerhardt had shown up on October 17th at about 9 o'clock in the morning. She claimed Mr. Gerhardt had entered the apartment through the front door using his key and grabbed her phone, checking it for messages. She relayed that Mr. Garhart had come to use the Wi-Fi. She said that Mr. Garhart didn't assault or harass her, and she wasn't trying to get him in any trouble. But they had been together for 14 years, and ever since his father had died, he had begun drinking heavily and things had gone downhill. She relayed that she had not intended to report Mr. Garhart for this violation since they had been working on things, but since he had begun messaging and harassing the third party, that had gone too far and she had to call it in. Officer Gergman read Mr. Garhart his Miranda rights, which he acknowledged. He waived electing to speak. The question, he admitted to violating the order in reference to that day, the 18th. However, he denied coming to the apartment on the 17th. He stated he had court around 9:30 and then had to be to work around 10 or 10:30. When asked if his court hearing was over Zoom, he stated that it had been. He continues over that morning, but when asked if Ms. Del Rosario was lying, he would never answer the question and would ignore it. He was searched incident to arrest. On his key ring, on the key ring to his Kia keys, officer observed a key that looked as if it would open the exterior door to the C building. Officer tested the key and it opened the door. Officer went to the apartment manager's office and spoke with Teresa Joyce. They compared the key to the keys on file for the apartment. While similar, they did not exactly match. At that point, I'll stop. The city is seeking probable cause for one count of violation, no contact order for coming within 1,000 feet of the residence. The additional information will be relevant in a bit.
I'm going to find probable cause. I see that the order that he's alleged to have violated is in his pretrial file issued September 25th by Judge Buckley, and specifically has a 1,000-foot distance restriction from that 5001 College Street address. All right. And so, yeah, I am going to ask Mr. Sharp if what your recommendation is for release on this, and I guess also whether that other incident you referred to is part of that felony prelim he has in Superior Court. Okay.
It is, Your Honor. I'm sorry.
The next question, I guess, also is whether you're going to ask for any revocation of release on the 435 case.
Okay.
All right, I was wrong. I jumped the gun a little bit. Now it's about to go down. Now we get to hear what he did, and yeah, not good.
Yes, Your Honor, we are. Substantial bail is the request here, moving to revoke probation, or I'm sorry, not probation, revoke release based on this new law violation, as well as the one alleged out of Superior Court. The reason I read in those additional facts is because they support probable cause for the felony of violation of contact order as well. Well, that's misdemeanor, but felony residential burglary for having entered the residence to violate that no contact order. Those are both bases for the city requesting this high bail. Looking back at things on September 28th, the city didn't object to a PR release on that date. The city deeply regrets that, because in hindsight, having become aware of how serious this matter actually looks to be, with more information on hand. I reviewed extensively the evidence files for that original case, as well as the body-worn camera footage from the officers on scene at the apartment investigating that original assault. I note that Ms. Kamari and I were both in court on Tuesday when Mr. Garhart, he was present on Zoom. He had a distinct background and caught the city's attention because he had lit up a cigar during another hearing. I did notice the background there with a particular lamp, as well as an office chair that he had been seated in. Officers were investigating that this morning, and we reviewed the body cam footage from September 25th and did see in the corner of the room that lamp, as well as a chair that matched the particular description. So that further supports the allegation that there was a residential burglary, and frankly makes it egregious that he would have the audacity to appear in court while committing burglary and violating the no contact order. During that hearing, he asked the court to rescind the no contact order because he asserted that the victim was pregnant. The city opposed that, arguing that that pregnancy being new information would actually further justify and reinforce the need for the order. The court at that time agreed, and for him to have made that request under those circumstances is beyond ironic and possibly tragic. City reviewed the body cam footage and observed that the alleged victim in that assault case, she was a mess. She had very apparent wounds to her face, Her glasses were broken. She was extremely upset. Again, I regret not asking for high bail under those circumstances alone. Now this is aggravated. Additionally, from Mr. Barr, officer was provided with a string of text messages from Ms. Rosario. One of them from 9/16 on October 17th states, quote, "Jordan's over here. He's on Zoom with the court and I need you to recant everything because he went through my phone and I'm straight up scared because he thinks we fooled around." Your Honor, Mr. Garhart presents an extreme danger to Ms. Del Rosario. He's shown an extreme disregard for the court's orders. City believes substantial bail is appropriate here, asking for $25,000 on each of these cases. Conditions on this newest case, including law-abiding behavior, no possession of firearms or other dangerous weapons.
Ms. Kamiri?
Yes, Your Honor. Again, we're requesting release on personal recognizance. As Mr. Sharp went through the police report, you see that there's another reasonable explanation for what happened. These hearings go quickly and it is unclear what exactly was made aware or Mr. Garhart's interpretation of the limitations that he had for the protection order as it relates to alleged burglary the day of. He was in court. Whether or not the background was specifically in a location at a certain time is to be determined. At this time, he had other places that he had to be that morning. And it's reasonable that he was not at the residence. As it relates to the incident for which we're here today, it's reasonable that he was going to get his mail so that he could obtain the death certificate that was supposed to be mailed to him so that he could handle his father's estate. And as you heard in the police report, it stated that he was not aware of the 1,000 feet restriction that was contained within the protection order. And all these allegations relate to going to an unoccupied residence and dealing with his personal matters with no harm to the victim. So request that he be released on his personal recognizance, Your Honor.
Okay. All right. For the current charge of violation of a protection order based on the allegations that were made regarding entering into the 1,000-foot restriction of the residence of the alleged victim, I'm going to set bail as requested at $25,000. And that is because I find that overall, in addition to the new charge, the other facts that Mr. Sharp reported after some other investigation by the Lacey Police Department, Mr. Garhart presents a clear risk to violate court orders, and he presents a clear risk to the victim based on the facts that were recited by Mr. Sharp. Furthermore, I'm finding by clear and convincing evidence that he's violated his release conditions on the 435 case. I'm going to revoke his personal recognizance release on that matter, or revoke his current release and impose bail of $25,000 as requested for the same reasons. I have to say I'm shocked at the factual allegation that he would, while violating the order, appear in court and then make a request to have the order rescinded. So that release is revoked. Conditions of release on the new case will be not to violate the law, possess firearms or dangerous weapons, and comply with current no contact orders. Now, we have a pretrial currently set on the 435 case on November 21st. Is there any reason we can't keep that date as is?
No, Your Honor, I request to keep that date.
All right. All right, we'll keep November 21st, and that'll be pretrial for both. Now, Mr. Robbins, I also have a state case here, a Tumwater case, I should say. Mr. Garhart is on a stipulated order of continuance for malicious mischief and reckless endangerment. Are you asking for any action on that?
The city is just making an oral motion to revoke at this time, based on the new law violation.
All right, we'll note that and set that for a hearing. All right, so Mr. Garhart, we're going to see you back here November 21st.
I ask that our office be appointed.
You already are. Yeah. All right, and, Brenda can have a PV date for the state as well. Sure. That's December 14th. All right. Your probation violation hearing date on your Tumwater case is going to be on December 14th. I'm not sure, but either way, we're just going to leave his previously set hearing date. Yeah. Okay, Mr. Garhart, you're done for this afternoon. You can go with the officer.
Thank you, Your Honor.
I believe that concludes the Lacey calendar for today.
I told you. It's crazy. He says he went over to get mail, ends up calling into court to Zoom into court from the victim's apartment when he's not allowed to be. He called into court from her apartment, not allowed to be there. He said he was with her for, 13, 14 years, so he might have had a key. Still, doesn't matter. It's still considered breaking in. Wow. Wow. All right. Do a little palate cleanser with Judge Simpson. I know we need it after that one.
Case People versus Jashawn Whitfield.
Jonathan Emmons on behalf of the people.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Jashawn Woodfield. Please state your name for the record, sir.
Jashawn Woodfield.
Thank you, sir. All right, what are we doing?
Thank you, Judge. My understanding is that my colleagues have spoken to Mr. Woodfield and to Mr. Emmons, and that there is an offer at this time, but the paperwork has not yet been completed. We could adjourn it for a couple of weeks. We can get the paperwork completed and maybe get this resolved.
Probable cause will be adjourned November 2nd, 2023, 9 a.m. Or as your Zoom invite indicates, bond will continue. All right. Thank you, Mr. Whitfield.
On Zoom, right?
Yes,
What? Why, you want to come see me?
No, I don't want to come see you.
Whoa. You had to put it that way?
Judge.
You had to say it all, you had to say it all like that?
No, that's personal.
It's
cold outside.
No, it's cold outside. That's that's all you got? Okay. All right, fine. I might even have to make his in person. Well, we'll deal with Zoom on the 2nd, but he may have to come see me because he doesn't want to.
Understood. Sorry, Judge.
You know, because I'm sensitive and that hurt my feelings.
We understand. And we apologize.
Judge, maybe I need to address bond.
No.
Please no.
He doesn't realize. Well, no, he does realize I can make him come see me.
Right.
We're not, I won't do that.
All right, thank you.
Okay.
Thank you, Your Honor. Thank you.
Thank you.
It was good. And then there's another one. Vincent.
Conrad Stoner on behalf of Pittsfield.
Corellis McCants. Mr. Hall. I think I saw Mr. Hall on there.
Emailing with Mr. Hall.
Oh, no. That's what was taking so long. It's Vincent.
Good morning, Your Honor. Michael Vincent on behalf of Ms. McCants.
Hey, good morning.
Say good morning to the
Good morning.
judge. State your name.
Corellis
State your
McCants.
name, please. Thank you.
Corellis.
All right. What are we doing on this case? She has not been arraigned. You waive formal reading, stand mute, Mr. Vincent.
Exactly. Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. All right. And what are we doing on this case?
We need an adjournment so Ms. McCants could obtain a driver's license. I received a email from Mr. Siller stating that if this is possible, a good chance for a plea bargain that won't affect your driver's license.
All right.
That's correct.
I'll adjourn this matter out to November 15th, 2023 9
Your Honor, can we have-
a.m.
Is it possible to have a later date? Because I think I don't do those, Joe does them, but it takes a while. The Secretary of State's got so many hoops to jump through.
Are you asking or is your staff asking?
My staff is asking.
Okay, then I'll do it. December, what is it? December 6th, 2023, 9 a.m. You know, that's what makes Mr. Benson a good attorney. He knew what the answer should be.
Oh, absolutely. As far as
Bond in this case will be set at a per $5,000 bond.
Thank you, Your Honor.
All right. Thank you.
All right.
Take care.
Okay.
Court calls the case, People versus James Lawson.
All right. We need that palate cleanser. Judge Simpson's always good for that. All right, we're headed back to Thurston County. This was all in the same docket. That first clip, this next clip, and then the last clip, all from the same docket. Kind of a crazy day for that judge. But yeah, let's go.
Can you hear me now? Okay, excellent. All right, and sir, over in the county jail, what's your name, please?
Juventino Placencia Arevalo, ven por Placencia, es México de Capital, la capital aquí. I came for a case, misdemeanor. I've been called right here with, I said I have no calls right here, I've got no felonies. I just got 2 misdemeanors so I can get released. This is the 19th, so I should be able to release this afternoon.
All right, I think that is Mr. Pazderka representing Mr. Placencia?
It's Mr. Stillwell, Your Honor, and I'll be covering.
Mr. Stillwell is okay. So just one moment here, Mr. Placencia.
I really appreciate it. You're going to be getting paid. You check the same amount of money you're going to get paid. Just remember, don't do your job. Hey, I've been generous.
Go ahead, Mr. Pong.
Based on the notes I have from Mr. Stillwell, Your Honor, we're going to be asking the court to keep this matter tracking with the Superior Court matter. Mr. Placencia Arevalo is not being held by this court, but he's being held by Superior Court. His next hearing in Superior Court is a treatment review hearing set for 10:30. So we would ask this court set his hearing for 10:31 to keep them tracking.
10:31.
Yeah.
Okay. State?
No objection, Your Honor.
All right, Mr. Placencia, we'll see you again on October 31st, and I think by that time your attorneys are going to have your case ready to go.
I thought it's supposed to be released now. I got family that got to go see. I cannot waste any more time right here. And close to home, I don't like this place inside right here. The food is horrible. And
Well,
the treatment is
Mr.
even worse.
Placencia, you've already been released by this court. It's Superior Court that's holding you. So you need to address those concerns to the Superior Court
This
through
is
your
what I
attorney.
need to do for me as a judge. I need to talk to the other judges to share your bodies and tell you to release me immediately. I have no other calls. I already saw time for this. I got time soon. I already saw more time, so I got time served. I appreciate it. Thank you.
Not sure he understands which court is holding him.
All right. Yeah, he tried to tell the judge what to do. It was kind of funny. Before we get into the last clip, if you haven't liked and subscribed already, please do so. Also, my link tree will be in the description if anyone wants to help out with the Demonetized Fund. All created. Now, let's get into the last one.
A person arrested is due in court by the next judicial day. If you're not ready for that case to be heard, you can just request the court clerks directly to put it to the next day.
Okay, understood,
Yeah.
Your Honor.
Yeah, that might avoid, the notion in the jail that they may have to put them in front of the court before they're ready to go to court, in other words. So that's a way to avoid that. Okay, lesson over. Sir, over in the jail, what's your name, please?
My name's John Gertz.
Say again?
My name's John Gertz.
Okay, and Mr. Gertz, Today you're here in court on your Lacey case. You're on probation for trespass, and there's an allegation that you're in violation of your probation because of new law violations. You're also in court because of a warrant that was issued when you missed your pretrial hearing for another trespass charge back on September 12th of 2022.
Yeah, which I had no idea.
So, well, let's get a couple things sorted out. Mr. Gertz, the only address we have for you is general delivery in Olympia. Do you have a better mailing address than that?
Okay, 161 Patterson Street, Northeast.
161 Pattison?
Yeah.
Okay. All right. And you actually get mail there then?
Yes, yes, Your Honor.
All right. Is that Drexel House?
No, that's not Drexel House. That's the interfaith.
Interfaith. Okay. Gotcha.
For the
All right. Let me hear from the state first then on that warrant.
Your Honor, the state would ask that he post $500 bail, and this is just due to the 7 active warrants out of, I believe, 3 jurisdictions. State has low confidence that he's going to appear for us to resolve this.
Do you know what brought him into custody today?
I don't, Your Honor.
Okay. All right, Mr. Capone.
Your Honor, we would ask that the warrant be quashed and that Mr. Gertz be released on his own recognizance. He has recently moved residences to a shelter near his old residence. He was relying on a girlfriend to pick up mail and bring it to him, but clearly unreliable as he was not getting notice of his court dates. And that is true for those other warrants that are outstanding. I believe 4 of them are from the same day out of Olympia and Municipal. With regard to the Walla Walla and the Lewis County ones, he did indicate to Mr. Gasling that he also didn't get notice of any of those. So I do think that this comes down to a notice issue, not necessarily malicious or intentional failures to appear into court. Mr. Gertz did indicate that he signed up for an opioid treatment program at Prosperity House, and he intends to do a substance treatment there. He's not working right now, so any amount of bail imposed would be tantamount to just holding him. So we would ask for his release and that warrant be quashed. Thank you.
And then Mr. Sharp, you got a case. He's in the other jail, but
Yeah,
I don't know. There was no warrant issued on the probation case. So are
Right,
you
Your
asking
Honor.
for any kind of a hold?
well, I'll be candid that it wasn't until Your Honor said there was a Lacey case that I became aware. So I don't think Ms. Kamari has got materials here. I don't know that matters so much, though. Mr. Hofstad was previously appointed and has withdrawn, so there's not any counsel currently appointed, and he's just here on a review by virtue of being in on state warrants. City would make a motion to revoke based on new law violations, and that's the Olympia charges from July. Would ask that he be reviewed for appointment of new counsel. I would defer to the court on bail, understanding I think the court's already aware of the 7 active warrants with 4 different FTA dates there.
Yeah. Okay, I'll appoint counsel for you in your Lacey case. I'll appoint Ms. Langley to do that.
Your Honor, I don't think Ms. Langley is able to accept any more appointments this year.
Did she hit her max?
I think she went past it.
Okay, then scratch that. We'll appoint Pacific Point then. Okay. All right, for the county case, Mr. Kirch, you have just failed to appear too many times. In the meantime, since you failed to appear, you've also been convicted of crimes in Olympia. So I am going to set some bail. I'm going to set $250 bail on your county case. And we'll get you back on the pretrial calendar with the public defender.
Okay, so how long?
And on your Lacey case, what I'm going to do is I'm going to set bail in that one as well at $250. I don't know if it'll make any difference if you're going to be held on your state case. And we'll set that one for a probation hearing with your new attorney. And since they don't know you and haven't had a chance to prepare any kind of a bail recommendation, they can always do that. The door's open for Lacey appointed counsel to request a bail review. All right, do you think you'll be able to post bail to get out, or will you be in custody?
I don't think I'll be able to get out now. That's why for PR.
Okay, yeah, I understand. So we'll get a hearing date set for you then. We need a county pretrial and a Lacey probation. Yeah, since he's gonna be in custody.
Probation, but the jail was closed, man. I went to go check in probation as soon as I got on this Squally jail, but the jail was closed down. I could not get into the building. I could not get a hold of probation for nothing. I tried for a week straight. I swear to God. As soon as I got out of Squally after serving 31 or 21 days, I went right to the probation department. The Lacey jail or the Olympia jail was shut down. I couldn't get in there. I couldn't get a hold of anybody. It's not like I failed to check into probation. It's that I couldn't get in there. I couldn't get a hold of anybody. And that was for like a week and a half. The whole entire jail was shut down in Olympia. Like for real.
Okay, November 11th is a holiday.
Quick correction for the record. So I just pointed out one case. I do see two others from Olympia. Same thing, but November 14th and October 26th of last year. So we've got 3 new law violations alleged to address at the next hearing.
Yeah. So November 28th for Lacey.
I'm gonna be here past my birthday. Are you kidding me?
Okay, so your next court date will be on November 1st. We'll see you here then.
Fucking retarded. Fuck you guys. Go ahead, you fucking asshole. Hey, have a seat right there.
I think that may give us some insight into his willingness to comply with court orders.
Well, there we go. There we go. Oh, it's kind of weird seeing me on the screen twice. All right, that was it. Yeah, his birthday. His birthday's coming up. They're gonna hold him past his birthday, and the jail was shut down. He's got some great excuses. I don't know why the judge didn't buy that. All right, though, that's all I got. That's it for now. Thanks everyone for stopping by. If you haven't already, liked and subscribed, and if you want to donate to the Demonetization Fund, click on the link below. Until next time, bye.